Hello everyone, and welcome to another episode of Legal Insights. Today, we're diving into an interesting case that clarifies bailment in the hotel industry, Taj Mahal Hotel vs United India Insurance Limited, 2019. Ever wondered what happens if you hand over your car to a valet, and it gets stolen? Who is responsible, you or the hotel? Let's break it down. The case background. This story begins at the Taj Mahal Hotel in New Delhi. A guest, just like you or me, arrived at the hotel and handed over his car to the valet for parking. He received a parking slip and went inside. Now, what's important here is that the guest had no control over the car once it was handed to the valet. But later, when he came back, the car was missing. The guest immediately reported the issue to the hotel management, but they refused to take responsibility. The matter was then taken to court. Legal concepts, bailment. To understand this case, we need to talk about bailment. What is bailment? Bailment, a legal relationship where the owner, bailer, delivers goods to another party, bailee, for safekeeping, with the expectation that the goods will be returned or properly cared for. Think of it this way: if you give your watch to a repair shop, you expect them to take care of it and return it, right? That's bailment. The same applies when you give your car to a valet. In this case, the moment the valet accepted the car keys, a contract of bailment was established between the guest and the hotel. The guest, bailer, entrusted his car to the hotel. The hotel, bailee, had a duty to take reasonable care of the car. If anything went wrong, the bailee, hotel, would be responsible unless they could prove otherwise. The legal battle. When the guest sued the hotel for negligence, the hotel tried to escape liability. Their argument. Hotel's argument: the valet parking was just a service, not a legal obligation. The hotel was not responsible for theft. Guest's argument: but Your Honor, the moment the valet took the keys, the hotel became a bailee and had a legal duty to protect the car. The Supreme Court examined the case and agreed with the guest. The hotel was responsible because they failed to take reasonable care of the car. As a result, the hotel had to compensate the guest for the loss. What about pledge? Now, you might be wondering, how is bailment different from pledge? Example of a person giving gold jewelry to a bank in exchange for a loan. Unlike bailment, a pledge happens when you give goods as security for a loan. The lender can keep the goods if the loan isn't repaid. Bailment, temporary transfer of goods for safekeeping. Example, valet parking. Pledge, goods are given as collateral for a loan. Example, pawning gold for money. Key takeaways and conclusion. So, what can we learn from this case? Handing over goods to another creates a bailment relationship. Bailees, like hotels, must take reasonable care of the goods. If a bailee fails, they are legally liable for damages. That's it for today's video. The next time you hand over your car keys to a valet, remember, if anything happens, they are responsible. If you found this helpful, don't forget to like, share, and subscribe for more legal insights. See you next time.